Hello, my name is Jay Chauhan. Today is the 29th of March 2019, and today's program is, uh, is based on how we as lawyers charge the fees and the impact of it in the community and what the educational background is that we get from universities and the bar admission course in preparing ourselves for the practice years. So that's my topic. Just as my background, that I am running this angel mentorship group, and anybody is entitled to go in this group. They're mostly lawyers and paralegals. We have about 180 people now, but this program is also open, and I want to make it open also to people in the universities, even faculties, and other people of institutions who might want to hear the connection between what education we get and how we launch the practice. So that's my intention in doing this program, and I'll be doing more of it in the near future. So first, by way of a background, I'm going to the bar in Ontario in and has been practicing over 45 years, and I have been a deputy judge in Ontario for about 24 years. In my capacity as a deputy judge, I had the opportunity to assess many lawyers' accounts and understand the principles that are applied to assess the legal accounts of lawyers. And when they disagree, they bring it, as most of you who are lawyers would know, that you can bring it to the small claims court. So there are two basic places where you take the accounts to be assessed. One is the small claims court, and the other one is the assessment officer of the court. Just for your information, the assessment officer at the court may hear it, but he's not a lawyer. And they react usually differently, in my experience, than the way the deputy judges react. So when you make a decision to have your account assessed, or a client makes a decision, which is a better forum? So we'll bring a little bit of discussion on that issue as we go. So I think from university education point of view, in the mentorship program that I've been running in the last, I would say, about 8 years actively, and even prior to that, not so actively, where we launched quite a few lawyers. Actually, I have learned a lot about how the university education affects the ability of the person who is called at the bar to launch a legal practice. So I want to do this video based on that experience that I got. And I was myself, I'm a graduate of the Osgood Hall, and also my recollection of what happened in the education and then the bar admission course, which does not in any respect talk really about the fees and how you should charge. So I want to address that issue today in this video, and I want to just begin by saying that when we build a client or understand the principles under which we work as lawyers in the province of Ontario, it is most important to recognize the general nature of the profession at large. And so this is not the title that I've heard, but this is what we are doing. In fact, we are a private enterprise legal advisory service, very unlike the medical service, which is paid for by the province, or the federal government subsidizes the program. And when you become sick in Canada, you guaranteed support from the medical service. You are not guaranteed that support, and in fact, I want to bring a little bit of the discussion in this video of how it works in a private enterprise system that we have for lawyers. So in different words, when you graduate and you call to the bar with no understanding of the legal fees and how to bill, you're making decisions within the framework of a private enterprise system, which is also a competition model. So just like the regular business. So if you're providing service, then the Competition Act says that you can charge your fees and whatever you can command in the marketplace. And that results essentially in the senior lawyers like me, I charge $4.50 an hour. Junior lawyers begin somewhere around $200 and they move up as they go. But important thing to remember is that there is no control over the system in terms of the Competition Act, but the effect of what you decide and how you decide on the legal fees has a huge impact on your client relationship between you and the client. And therefore, that also is not even taught in any school, actually. How do you relate to the client? And the silent message of the university is that you're a lawyer and therefore you're entitled to bill, and what you bill they should pay is the implied message of the university. But in the real life, unless you're downtown where you guaranteed the clocking of the hours and get paid, you'll not get paid like that in the suburbs where I am. I'm in Richmond Hill, Ontario, and my experience over the last many years of how you build a client is that you are always bargaining, you are always struggling to get your fees paid, and just about every client that I can think of is always trying to figure out the ways he can haggle. And fortunately, most of the items in Ontario or Canada are not being haggled. But I'm also an advocate in Gujarat in India, where you can haggle for everything, including legal fees, vegetables, everything. But in Ontario, you still haggle for the car that you buy and the lawyer's fees as well. So that's the environment you're going to begin to practice in. So how do you deal with that environment is, first of all, I suggest that you keep a very good log of the fees, because the log is not just a record of the fees and the time that you spent, but also it affects your negligence, it affects your retainer. What were you engaged to do in your retainer? And when you are doing that service, did you focus on that issue? Did you identify the legal issue that you were to work on? And did you record your time based on what you did? So one of the students actually has noticed how they react to this arrangement is to simply describe all the events that they perceive. So, but in my view, the more accurate way to deal with the legal fees and your record keeping is to identify the function that you have to perform as a lawyer. So let me give an example. Suppose you have a liquor license application to be made, and you have, if you have not agreed on a fixed fee retainer, and you're going to bill by the time, then you should record what is it that you did. Did you actually spend time completing the application? Did you review the letter of the liquor board? Did you do something that you should be doing to review the information, advise the client, carry out the function, you appear before the board or a court, and did you record that time? So the documentation, advising the client function, appearing in the court are all relevant events that are important to record properly in the way you record the time and then the fees that you charge by the hourly rate. So I think it's very important that you have a proper logging system for both record keeping to build the client with, but also in the event of a dispute, you will see that there is always a correlation actually. If you didn't educate the client properly as you went along to say how you bill as a lawyer, then there is often a resentment that builds up between you and the client, because the client is wondering that how come an electrician will bill $30, $40 an hour, but a lawyer billing $400 plus an hour, and therefore there is a certain amount of resentment. And that resentment to pay the legal fees seems to be almost universal. I think right up to Shakespeare's time, you would see in his novel actually, Kill All the Lawyers, is because there is a resentment about the role of the lawyer. So I think my view is that we as lawyers have to do our due diligence to educate the public how we charge the fees, why we have to charge the fees. And since we do not have a pro bono system that is regular, or the legal aid that covers everybody, it usually covers landlord and tenant type of cases, family cases, but the middle class of Canada does not get the real support they should give. I just want to give you one example that I'm handling right now, and it has made it difficult for me to decide what is my duty and the role to advise this client. This client was working in a bank, and somebody forged the signature to write out the resume of this person, the letter of recommendation, which he did not sign. And there was ample evidence to show that it was not signed by this person. She was still fired because in the institution, they felt that if anybody is simply involved in this activity, then it would discredit the bank, and the action was commenced, and therefore the person had to defend the action. Now, this person does not have a job. They're living typical middle-class life. They have no recourse, no money to pay the legal fees, because the legal fees, unlike many of the things that you budget in your family budget, like groceries, the mortgage, to my knowledge, in all the reports I see in Globe and Mail, etc., the legal fees are never budgeted. So I think you have to start with the premise that when you deal with a client and you have a legal practice, what is your duty? The annual return of the Law Society will ask you, did you do any pro bono hours? Entirely voluntary. But I think in my view, at least my practice and what I suggest to people I work with in my group, that we ought to do a little bit of the charity since the society is not providing us the funds to do charity with. There are certain pro bono organizations that are there that are supported with grants and support, but essentially the client and you are on your own to decide what you will support as a real genuine case that you ought to support to protect the right of the individual in society. So I think if you have a dispute on the issue, where would you go? I think we have a dispute. There are two forums, as I mentioned earlier, to resolve the dispute. Actually, I think most of the clients are not very familiar. If you go through the assessment route, you have a certain notice time period. Within a month, you should give a notice to the client that you're getting it assessed. The clerk of the court appointed to assess the fees is entitled to hear, just like a courtroom, but he's not a lawyer, he's the clerk of the court, but his order then becomes a part of the court order, and if you need to appear before the judge to then finalize the order. But most of the time by law, that order of assessment becomes enforceable to the legal process as a judgment against the client as a debtor, and you can enforce the court order and collect the fees from him. If you go to the small claims court, the judge is a deputy judge, is always a lawyer, at least 10 years of training. He has seen the challenges and pitfalls of practice, and he, in my observation, is a bit more sympathetic. But the chances are, even me sitting as a judge in many experiences that I went through, essentially you will feel that to try to balance the right of the client against that of the lawyer, you will end up thinking that the client needs the support and you're going to try to compromise, I think, in terms of the fees. So when you make a billing and you anticipate a challenge in the court, you should always keep that in mind. So no harm trying to basically say that, look, my fees are X number of dollars, I'm going to give you a discount, but if you have a dispute, then I'm charging the full amount. Actually, I was talking to somebody in our group, and in the commercial arena, we have an accountant in the group actually, and her experience is that you always give in the commercial environment a discount. And the lawyer, what you can say is that if you pay the amount in a certain number of days, and if you don't, you'll charge interest at the designated rate. And in the Courts of Justice Act, that interest rate is then applicable once you notify the client or the ex-client that you're going to also charge the interest. So these precautions are very important to put. And the tendency for the lawyer is that most clients don't even know, don't even recognize that most lawyers are very diligent and very careful about recording their time. And in fact, most of the time, if you see and you have to reconstruct the account that you're doing, you'll be compromised the account because you feel somehow you ought to. And why? Because I think we're professional types and we are engaged in providing the service. We're not doing business. So therefore, although our model is a business model for work, we end up trying to compromise the fees. So I hope that the program was helpful, and hope you join this group, Angel Mentorship Group on the Facebook, and see you again. Thank you.